Good morning, everyone. Welcome to the Utah Court of Appeals. I'm Judge Ryan Tenney. I will be chairing today's panel, and please be joined by my colleagues, Judge Orm and Judge Harris. We have one matter set for argument today. It's Canteros-Alvarez versus Green. If counsel could enter your appearances, we will start there.
Morning, Your Honors. Taylor Cordsman and Kendra Brown on behalf of appellant Lupita Angel Green.
Welcome. And which of you will be arguing?
I will.
Okay. Let me make sure I pronounced your name. I don't know that I've ever verbalized your name before. How do you say your last name?
It's Cordsman.
Cordsman.
So
okay.
the I-E is silent.
Got it. I would have said that wrong. Welcome.
Morning, Your Honors. Olivia Shaughnessy and Taylor Webb on behalf of appellee.
Welcome to both of you. And who will be arguing?
I will.
Okay. This is good to know on both fronts. You've all been here to our court in various capacities before, but let's just set the ground rules to make sure we're all clear. We allot 15 minutes per side per argument. There's a clock at the podium. It works backwards. If we're asking you questions and you're at zeros, don't feel like you need to engage in the formalities of asking for permission to answer. Feel free to answer whatever questions are pending, but if we're at zeros and there are no questions pending, it's probably time to wrap up. Are there any questions before we begin? Okay. If not, Mr. Cordsman.
Good morning, Your Honors. As I said, I'm Taylor Cordsman. I'm here on behalf of the appellant, Lupita Angel Green. The question at the heart of this appeal is relatively straightforward. Is a single text that says, in effect, I hope you take a swing at me so I have an excuse to beat you up. Does that constitute abuse under the Cohabitant Abuse Act such that it can place a person in reasonable fear of imminent physical harm and justify entry of a protective order? And the answer is no. And I'd like to explain 3 reasons why today. First, when you look at the language of the text, it's obvious that it doesn't qualify as a real threat. Second, there's no evidence in the record that Ms. Canteros-Alvarez actually feared imminent physical harm as required by the statute. And third, to have a protective order entered against her, Ms. Green must have intentionally or knowingly placed Ms. Canteros-Alvarez in reasonable fear of imminent physical harm.
And is that the sequence in which we should consider those 3 criteria? It occurs to me that if we conclude that text was not a threat, it was a conditional indication of what would happen if the other person initiated violence. If we buy that argument, do we have to monkey with the other 2?
No, Your Honor. Each of these arguments is independent and sufficient grounds for reversal. And so if the court agrees with appellant on any one of them, there is no need to reach the other issues.
Can I don't know which of those 3 my question goes to, but I'm going to ask it. It feels to me like the focus of this thing is the text, and the text is clearly the most, it's the thing that is most directed at a potential threat of physical harm. I'm wondering, though, whether the analysis should incorporate the subsequent stuff as well in terms of how to interpret the text. And this is what I mean by that. In the stalking context, which feels a little bit analogous, we've got all this discussion about course of conduct, and you take everything holistically. You sort of, when you're trying to figure out if the course of conduct would cause a reasonable person fear or distress, you look at everything collectively. And here, what I'm wondering is this. She sends the text in July, and I know there's a back and forth about how to interpret the text. But then after that, there's this escalating series of things. There's the phone call to Taylorsville PD, there's the DCFS threat, and so forth and so forth. And I'm wondering if it's not correct to take all that other stuff, add it to the text, and say, after the text, she then starts doing all these other things too, and that makes it seem like she's really aggressive, and it sort of like adds additional flavor to how to interpret the text. You see what I'm saying?
I do.
Yeah, please respond to that.
Yes. The answer is no. That other stuff should not play a role, and there's multiple reasons why. First, if the issue is whether the text constituted an act of abuse, the question is whether it, at that moment, placed Ms. Canteros-Alvarez in reasonable fear of imminent physical harm. Things that happened after the fact cannot retroactively place her in fear of imminent physical harm, particularly when they're happening weeks or months after the fact. And that timing actually demonstrates that, in fact, any threat that was posed by the text was not imminent. And second, because the commissioner and district court by extension, that is not the ruling that it made. It held that all that other stuff was irrelevant because it did not relate to a threat of physical harm. It dealt with stress of litigation or potentially even harassment that could qualify maybe as stalking injunction or something like that. But stalking injunctions and protective orders under the CAA are substantively different. One deals with abuse, one deals with harassment. And while certainly there can be overlap between the two, things that are harassing but do not relate at all to a threat of physical harm cannot retroactively make a mean-spirited but ultimately non-threatening text into something that could reasonably or could cause a reasonable fear of imminent physical harm.
Can I ask about the first argument you mentioned, this true threat thing? I guess I wonder what the basis for that argument is. It looks like what the commissioner did was just engage with the statutory language and try to fuss with the question of whether this text message met the statutory language. The true threat stuff, at least as you've briefed it, appears to be in the nature of almost an affirmative defense. It appears to be constitutional in nature. And I guess I wonder whether, where I'm going is their preservation argument on that. The extent to which you think the commissioner had it actually in his mind that there was some sort of constitutional question here about a true threat, as opposed to just whether the statutory language was met.
Yes. So in response to that, first of all, we believe that this issue was properly preserved for appeal.
How?
Yes. The reason why is that an issue is preserved for appeal when it's been presented to the district court in a way that they have an opportunity to rule on it. And as this court has explained previously, although the court views issues narrowly, new arguments, when brought under a properly preserved issue or theory, do not require an exception to preservation. And here, Ms. Green affirmatively told the commissioner that the text did not constitute a threat. She said, I threatened her, that's not true, here's the text.
Right, but the statute doesn't use the word threat.
Yes.
Right, so whether it's a true threat or not doesn't seem to be sort of relevant to whether it meets the statutory language. The statutory language requires intentionally or knowingly placing another in reasonable fear of imminent physical harm, right? I'm not required if I'm interpreting that statute to assess whether something's a true threat or not, right? Do you see where I'm going with this? Like the true threat seems to be this constitutional argument that comes in as an affirmative defense, it seems to me.
Well, I think the point that you're making that the word threat does not actually appear in the statute demonstrates that the issue was properly preserved because the district court did engage in that analysis. He said, the issue for me here is whether this is an actual threat. And that's what I have to determine here today. Even though threat doesn't appear in the statute, he said that's the issue that he had to run
What
through.
can you point to in the record that indicates that the commissioner was engaging in that inquiry in the same way you are now, in terms of it being a First Amendment question?
Well, I think it's not so much the First Amendment is certainly relevant, but it's less of a First Amendment question and more of just what the CAA requires. Because when a statute allows pure speech to be penalized, it has to be interpreted and applied consistent with the First Amendment. And so the First Amendment informs how the commissioner was required to interpret and apply the CAA. And we see that in how he actually interpreted and applied the CAA. He said, looking at this, I need to determine whether it's an actual threat. And so here's what I'm going to look at to make that determination. And then he ultimately said, this is an actual threat, but our contention on appeal is that there's no evidence in the record that supports that legal conclusion. So when it comes to, I guess to continue on that same topic, A true threat requires a serious expression conveying that the speaker means to commit an act of unlawful violence.
I mean, this text, I get the arguments on both sides. The commissioner said this was close. I share the sentiment. I get what you're saying about this text is conditional, but this text is also fairly aggressive. I pray to God that you swing first so that I can beat the shit out of you. If I get that text, I feel like somebody wants to come fight me. I mean, because that's the import of this text. Explain to me, give me your best pitch on why that text wouldn't place a person in reasonable fear of imminent physical harm. Because it sure feels like a statement of we're about to have violence, doesn't it? And why isn't that enough?
Because it's expressly conditioned on the other person taking an action first. The communication, as explicitly found by the commissioner, he says this is what it means.
What if we, no, I cut you off. What if we took out the conditional language? What if the text instead simply said, I'd like to beat the shit out of you? What would happen then?
I think that would be a closer call, Your Honor, and we'd have to look at other context and things of that nature. But the fact is that here, we do have the condition. And the condition means that no violence will take place unless that other position or that other condition is met.
I'll give you the opportunity to duck it again, but I'm still toying with it though. Like what happens if a person sends a text and says, I'd like to beat the shit out of you? Is that abuse under this thing? Because I feel like that's what the commissioner was grappling with. Reading the commissioner's sort of thought piece as part of his oral ruling, you know, the key part of his ruling, I think, is where he says that he views this text as an expression of anger, that there appears to be some desire to engage in a physical altercation. And I think that's a fair reading of it. And so if the Combat and Abuse Act is saying that you can get a protective order based on conduct that would place a reasonable person in fear of violence, if you say something in the text like, I want to fight you, like I want to fight you, why wouldn't that be enough?
That wouldn't be enough for a couple of reasons. First of all, again, it's not saying, I'm going to attack you. It says, this is something that I would like to do. It is an expression of desire, not an expression of intent. But the second reason that it wouldn't be enough, and this is actually leads into my next issue, is that it would not it would not cause a fear of imminent physical harm. There's an imminence requirement, and there's a difference between somebody texting and saying, I'm coming over to your house right now and I'm gonna beat you up. Or I'm coming over to your house right now and we're gonna throw down. And saying simply, I would like to fight you at some indeterminate point in the future. The latter does not give rise to an imminent threat of physical harm.
So in simple terms, you're thinking this was not an immediate threat of physical violence or an indication to cause harm, because the person receiving the message can say, well, it ain't gonna happen because I'm not gonna swing first.
Yes, that is correct.
And I think the second piece of it is, even if you remove the condition, if the expression of anger is, at some point we're gonna fight, I think you're telling us now that that's not even enough, because the at some point part takes it away from imminence, right?
Yes, that's correct. And I mean, that follows directly from this court's own case law, where the court has explained that an imminent threat occurs when a person is told that she will be subjected to physical force presently, but a threat directed to some indefinite time in the future is not an imminent threat. And so we do have to consider all the statutory requirements when we're making that determination.
And
So
that you just quoted, remind me, is that the Farmer case?
that is Farmer, yes.
So can I take you, I know your time's up, but I still have at least one question. I'm guessing the others might have some more as well. Can I take you to standard of review? So the commissioner kind of agonized about this, it looked like. He kept talking about what a close call this was and by the narrowest of margins, and you don't often hear trial judges speak in those terms. But assuming we have a deferential standard of review here, we defer to judges on close calls. That's kind of the point of deferential standards of review. So I guess I'd like your thoughts on what pieces of this we review for correctness and what pieces of this we review deferentially. For instance, on the question of whether there's a subjective fear on the part of the recipient, That feels factual to me. But the objective part, maybe that's something we look at more on a correctness standard or review. The question of imminence, I guess I'm not sure. Is that a factual determination, or is that more in the nature of a legal determination? So I'd like your thoughts on which pieces of this are reviewed deferentially and which aren't.
Yes. So the question of whether this constituted a true threat or an actual threat at all, that is reviewed for correctness.
And that's the constitutional question you've put in front of us.
Yes, I mean, as I expressed, I believe it's deals more with the proper interpretation of the CAA in light of First Amendment principles, but that is correct.
Well,
Okay.
it's a written statement. And typically, the appellate court is in as good a position as the trial court to take the plain meaning of something that's written.
Yes, I agree with that, Your Honor.
But what about subjective, the subjective nature of being in reasonable fear of imminent physical harm? Is that factual?
That is factual, yes.
But,
And
but,
so-
but there's a fight, as I understand it in the briefing, about whether that's even an element here. So that would be legal, right?
Whether it's a required element would be a legal determination. Whether that subjective fear was experienced would be a factual question that the court would review and say, is there evidence that supports that finding or that inference? And in this record, we believe that no, there is not any evidence, as the text and the appellee's own actions and response to receiving the text amply demonstrate. And then, sorry, I know my time is up, but to answer the rest of your question, when it comes to the requirement of mens rea, obviously whether that mens rea was met would be a factual question. There's also a debate on what the mens rea requirement standard requires, and that would be legal. And unless the panel has any further questions for me?
I don't see any pending. We kept you over, so you'll have your full rebuttal.
Great, thank you.
Great, thank you. Thank you, Ms. Shaughnessy.
May it please the court, Olivia Shaughnessy on behalf of appellee. I think unless the court has any questions on preservation or true threats, I think it probably makes sense to pick up where my friend left off with the statute itself. She makes a challenge to the abuse statute on 3 grounds: the intent requirement, the reasonable fear requirement, and the imminence requirement. First, Ms. Green overreads the statute to suggest that she must have intended to cause fear. And she does not grapple with our analysis of the Patole case, particularly paragraph 19 and footnote 3. This court has said that for abuse under the Cohabitant Abuse Act, that the abuser does not have to intend to cause fear, just has to intend to act. And I think that's dispositive here. This court has distinguished abuse from domestic violence in that context. And while domestic violence may require some sort of criminal intent, abuse, this court found, is broader and does not require that specific finding. And so I don't think that adding a criminal mens rea to that is appropriate here. But nevertheless, if this court believes that she did have to intend to cause fear, I think the evidence is adequate here. This court should defer to the district court's finding that Ms. Green expressed a desire to physically harm Ms. Canteros, and that's enough for the intentionally or knowingly requirement.
Can I take you to the imminent threat part of all this?
Yeah.
That's the part I'm most troubled with on your end of this problem. What's your best evidence to show that there was anything imminent about the physical threat?
So I think it's important to think about protective orders in general. I mean, they've kind of advocated for a more immediate threat, right? They're citing the assault statute or the use of force criminal statutes, where imminence is really the pinnacle question, right? Someone has to be on your doorstep and threatening you before you are justified in using force. And the entire point of a protective order is to take that a few steps back and to protect victims from having to wait until things get really out of control before.
But here the waiting is on, your client's part. If she opts not to take a swing at her sister, the immediacy seems to vaporize.
I think the conditional requirement that my friend advocates for is very problematic in a protective order context. And I don't think this court needs to look any further than the Moda case that we cited in our brief. At paragraph 2, in April 2011, Jennifer was at home holding the party's youngest child when Lawrence threatened to commit suicide and picked up a handgun. Jennifer attempted to call 911. Lawrence then pointed the gun at Jennifer and the child and said, "If you dial the last number, it will be the last thing you ever do." And I think that is just as conditional. And, my friends have advocated that all she has to do is refrain from taking action in order to avoid getting assaulted.
That feels a little different to me, where there's a drawn gun.
I think,
I mean, when there's a gun drawn, somebody's drawing on you, that feels like an imminent threat of harm
That
to me.
seems like immediacy writ large.
I think even if he wasn't pointing the gun, even if the gun was just in the room, it shows the problems that it can occur when we take the conditional nature too far.
Well, okay, but we're in a situation here where there's no gun. They're not even in the same place. We're talking about a text message that gets sent, so the conditional statement when the gun is drawn, yeah, okay, I think that's. I get why that case came out the way it did, but this feels different to me, where they're not even in the same room. There's no weapon. There's no, a text is sent. Nobody's right there to punch anyone. Is that? It feels different to me. Tell me why that.
Yeah,
Tell
and
me why
I
that's
think,
wrong.
this court, it was an unpublished opinion, but in Camp v. Klein emphasized that it's not physical proximity that matters. It's the whether the threats cause the victim to presently fear for safety. So I think that is a better distinction to draw than to say anytime it's a text message, if you can just kind of avoid the situation,
Right,
that's close
you
enough.
add both text message and lack of physical proximity to the conditional nature of the message, and you put those two things together, can we get to a point where there's not imminence, or do you think there's still imminence when you put those two things together?
I think that you can still find imminence. I think that, like I said before, it needs to be a little more relaxed when we're talking about protective orders and speech that justifies entering a protective
And the
order.
imminence question, do you think that's factual in nature, or do you think that's something that, as Judge Orm says, hey, we can read the text, we can review that as well as a trial court can?
I think that is a factual determination that is baked into the court's finding. I mean, they argue that the court didn't make specific findings on imminence, but I think when you read the entire context of their relationship, you can defer to the trial court and that the findings were sufficient on that point.
I'm wondering, back a paragraph or two in what we were talking about, I get why you're citing Moda. They've given us a citation, this almost feels like dueling citation at time, but they've given us a citation for Farmer, which I thought about as well. And Farmer's got this language where it says, it's talking about imminence, it says a threat directed to some indefinite time in the future is not an imminent threat for purposes of defensive compulsion. I know that we're in compulsion territory, not in protective order territory. But let's just assume that I think that has some bearing on what imminent means. A threat directed to some indefinite time in the future is not imminent. Well, if I think that legally helps here, and I'm back to this text, it feels to me like this text sort of fits that rubric. It feels like a threat to me. Probably, it's conditional, but it also feels like it's very indefinite. I pray to God that you swing first so that I can beat the shit out of you. I wish I could go back in time and punch you in the face. It feels like to the extent that she's talking about, I want to hurt you, I don't know how to fix the time in which she wants to hurt her. But the statute seems to fix the time. The statute seems to say imminent. So now I'm back to the imminent question. And that was more of a Breyer question, that was more of a thought piece, but help me with that though, because
Is it a Breyer question or an Orem question?
or an Orem question, I mean, you say potato, I say potato, but, it just feels like I take your point, like, this text feels violent to me, and I take the commissioner's point, it feels like it's an expression of a desire to do violence, but the piece that I'm struggling with is when is she expressing a desire to do violence? And if I can't pin that down, I wonder if we're in farmer territory.
Yeah, I think that is a hard line to draw. Where do we draw that line in this context? That's not a criminal context, but I think as a policy matter, we give that a little bit more breathing room than we do in the criminal context.
Walk me through that, because I think that's your best argument, but I want to make sure I've got my brain around it. Walk me through why that's so.
Like I said earlier, the criminal context, that trigger between when you are justified in using force and when you're not really hinges on that pivotal question. And here, I haven't found a case that's directly on point that has ever drawn that line. And I don't think that this court should do that here. I think that the findings here are sufficient to show that she was in reasonable fear of imminent harm.
I know we didn't talk about it in the other side's argument, but this question of whether subjective perception is an element or not, I find interesting here. Can you give us your best pitch on your view of how that should play out?
I have two thoughts on that primarily. First, there is no the statute itself does not impose a subjective test the way that it does in other statutes. So it is a purely objective standard facially, and that's also confirmed by this court's precedent in Moda and Card. Both of those cases applied a pure objective standard, and my friends over here try to distinguish that and say that the posture was different because that was a motion to dismiss a current protective order as opposed to appealing the protective order in the first instance.
Can I push back on that a little bit? The statute here doesn't say place a reasonable person in reasonable fear of imminent physical harm. It says placing the other individual in reasonable fear of imminent physical harm. And that feels subjective to me. So their argument is there's both a subjective component and an objective component, and the subjective component comes from the statutory words another individual as opposed to a reasonable person in that person's shoes. And then the objective part comes from the word reasonable. The fear must be reasonable. Why is that wrong?
So I think without that extra language like you have in the stalking injunction context that says in that person's circumstances, you do just read it as a reasonable person, an objective standard like this court has already applied in both of those cases. But ultimately, at the end of the day, a subjective standard doesn't help them, and especially on appeal. So I'm not quite sure where they're coming from on that, because if we really want to open the box of subjective fear, there's ample evidence to support that my client was in subjective fear when she received that text message.
What's the best evidence of that?
I think the court can look at everything, and that goes what we're talking about earlier. You can look at the entire context of their relationship. And
I mean, pushing back though, because if the text places her in subjective fear, but then if I got it right, she comes back with the car that evening, which seems a little anomalous. If I'm afraid that you're about to beat me up, I'm probably not driving to your house that night.
Again, that's a a problematic road to travel down when we're talking about domestic violence protective orders. The fact that a victim capitulates to what their abuser is requesting of them quickly becomes a problematic analysis to apply. And I mean, if we're really going to look at subjective, she told the court how she interpreted that message. And so she said that she was in fear. The petition itself asks what the conduct was that made her afraid, and she details all of those things. She testified at the hearing that she was worried. So I think on this record, there's enough to support a subjective finding.
Although some of what she's worried about is the guardianship petition, right? And the interference in her relationship with her son.
Yeah, I mean, again, I think you can consider, this court can consider the whole context of their relationship. Everything's fair game on appeal to support the district court's finding, and everything the court considered is fair game. And I think it can be problematic to try to draw a line between what she was afraid of, and I think the whole context should be taken into account.
Although if what you're afraid of is interference with your parental rights, that is not necessarily suggestive of any immediate physical harm.
Right. She was worried about her behavior was becoming erratic. And when you look at the impetus of this text message, it was because she didn't return a car, and suddenly you've got these threats of violence. I mean, the context matters, and that includes kind of the context of what the text was sent in as well.
Can I take you to the First Amendment issue? There's an interesting fight here about whether it's preserved. I mean, I looked for it. I don't see any reference below. Granted, both parties were pro se, but they're not speaking to the commissioner in terms of you need to interpret the statute in light of the First Amendment. That all works for me. I've written my share of preservation rule opinions. But that said, once I start articulating that, I run into the following mental roadblock, which is it feels a little bit anomalous to say out loud, you don't have to interpret this statute consistent with the guarantees of the First Amendment of the United States Constitution. And so I try to imagine writing the opinion or signing the opinion and dropping a footnote saying, hey, we're not going to address whether this statute can be interpreted outside the realm of the First Amendment, and that feels funny to me. I'm wondering if I can get your reaction to that. Why we wouldn't just, as a matter of course, address the First Amendment argument, because it would be, this isn't a Latin term, it would be strange not to.
I think it would be strange too in this situation. I mean, she is asking this court to extend a complicated doctrine in a way that it hasn't been applied before by this court, and is trying to do so in a place where she didn't even ask the district court below to conduct this analysis. She never even said below that her First Amendment rights were violated.
But surely it can't be the case that a district court or a commissioner in this instance can interpret a statute outside the realm of the Constitution. So that's the roadblock I run into. The preservation czar in me is buying everything you're selling, but then the pragmatist in me is saying, how could I join an opinion or write an opinion that says that a statute doesn't have to be interpreted consistent with the First Amendment?
You can look at your own prior precedent that we've cited. I mean, there are some pretty tricky cases where someone below mentioned their right to possess a firearm, and this court still said that that wasn't enough because it wasn't raised in a specific context. And so, every case we've cited, I mean, other than they cite the Bell case where this court looked past preservation because someone was pro se below. Right. But that's because the appellee stipulated to the error on appeal, that weighed just as heavily. So I think this isn't even a close call. And while especially a pro se party may not be held to an exacting standard and may not need to use magic words, there has to be something there. And there just wasn't here. And it's not a straightforward legal error application. Like I said, this is a really complicated doctrine, and it has not been applied like this before.
Okay. Do we have any opinion questions? Okay, we've kept you over. Thank you.
Thank you.
Well, thank you. There's just a few quick points that I would like to make on rebuttal. First, to continue along this same line of question that we were just on with regard to preservation and a true threat. Here, again, we are dealing with a pro se party. She told the commissioner and argued to the commissioner, this is not a threat. In context, that is a legal challenge to this text serving as the basis of a protective order because it does not constitute an actionable threat. And that sufficiently preserves the issue for appeal. Second, with regard to the subjective perception requirement, Judge Harris, I think you were correct in your analysis when you're reading the statute. It says that you must have intentionally or knowingly placed another reasonable fear of imminent physical harm. If that person wasn't actually placed in reasonable fear, then there is no basis for the protective order, even if another person reasonably would have feared under those same circumstances. And here, again, we don't have to speculate about what was going on in Ms. Canteros-Alvarez's mind in response to this text, because she tells us in the record. She said, she gets the text, and this is page 92 of the record, and she gets the text and she says, I just ignored it. I was like, I'm not gonna engage with this behavior. I told her, I can just leave the car here and you can pick it up when you drop off. Like you said, that's fine. At another point on page 79 of the record, she says, after she received the text, she said, after I dropped off the car, I was just like, just leave me alone. Like, I don't really need to talk to you anymore. These are not expressions of subjective fear. These are a person who is exasperated and annoyed with their sister, with whom they are having an argument. And then lastly, with regard to the mens rea requirement, I disagree that the Patol case stands for the proposition that my friend on the other side says. The Patol case was very different in that it was a woman who did a wrestling head throw. She threw her husband over her shoulder and then held him on the ground and put him in a headlock. And the court said, well, she's not arguing that this was unintentional. She says she was justified. And there, the question is not putting somebody in fear of physical harm. The question is causing physical harm. And the action itself was the exact same thing. Like, I intended to throw him on the ground and put him in a headlock is an admission to intention to cause that harm. And we can think of
Go ahead and finish your thought. You're good.
Okay.
Yeah.
I was just going to say, I think we can think of the consequences of eliminating the intentional or knowing requirement. So take, for example, I come home late one night from work. My kids are in bed, my wife is alone in the kitchen. She doesn't hear me come in the door, so I pop in and I say, hey, and she jumps out of her skin. She's scared witless because I startled her. And that's not necessarily unreasonable. She was alone in the house and now she hears a male voice who's suddenly present. But it wasn't my intent to put her in fear of imminent physical harm. And she is not a domestic violence victim as a result of that. Even though I intentionally and knowingly came in the house and spoke to her, and those acts put her in reasonable fear at that moment, absent the intention to cause that fear, it is not an act of domestic abuse. And unless the panel has any further questions of me, we would ask that the court reverse and remand with instructions to enter judgment in favor of the appellant. Thank you.
Thank you. With that, the case will be submitted. I want to thank you both for the briefing and the arguments today. I thought the briefs on both sides were uniformly excellent, and I very much appreciate the arguments today. They were both very well done and very helpful, so thank you to the both of you. And with that, we'll be adjourned.